Good morning and a very warm welcome to all of you. For those of you who don't know me, my name is Aideen Hartney and I am the Director of the National Disability Authority. And I'm really delighted to welcome everyone here today to the launch of our report, which is titled The Journey from Wardship to Supported Decision Making, an examination of the process and the experiences of people leaving wardship. So just before we get to the main part of our webinar this morning, I want to quickly run through some housekeeping, so please bear with me. Today, we are joined by Irish Sign Language interpreters. We have Willie on screen and Leila will join us during the meeting. And thank you to you both. And there is also automated captioning of this webinar available. And this is available on the bottom of your screen by clicking the Show Captions or the CC icon in the toolbar at the bottom. If anyone has any technical difficulties during today's session, please just use the Q&A function, which is also at the bottom of the screen, to alert a member of our staff. We do have NDA staff monitoring this Q&A function, and they'll be available to assist you. Today, Dr. Nora Donnelly and Mr. Kieran Finlay are going to share the main findings and recommendations from this research. We had hoped that it would be possible to have one of the participants in the research who had been discharged from wardship also make a contribution to talk about their perspectives on the research. And we did invite a number of people, but as you can imagine, this can be quite a difficult thing for them to do. So unfortunately, nobody took up on our invitation. But following the presentation from Nora and Kieran, we will have an opportunity for some questions and answers. So if you want to participate in the Q&A, please use that Q&A function also at the bottom of your toolbar. And please note that you won't be able to see each other's questions as they're submitted, because this can be disruptive for people using a screen reader. So what I will do is I will relay the questions to our speakers who will be in a position to answer them. Before you input a question, please do state your name and whether you're part of an organisation at the start of the question. And if we run out of time and don't get to answer all the questions, you can always follow up with us by email. You can reach us at wardsresearch@nda.ie, and I'll have a reminder of that email address at the end of the session. Just to note, we are recording this webinar for people to access after the event, and we will upload it to our website in the coming weeks. But as this is a Zoom webinar, you as attendees will not be visible. So we're very proud to have undertaken this important research, and it is the culmination of over 2 years' work at today's launch. The report is published to our website, nda.ie, and there is also an easy read version of it there as well. And the purpose of the research is to examine the real-life experiences of those leaving or preparing to leave the wardship system, and it sets out key learnings and recommendations that might help address some of the concerns and apprehensions that were raised by participants during the research project. And we hope that all this information might be helpful in charting a path forward. I want to take this opportunity to acknowledge the support we received from a number of stakeholders in carrying out the research. First, we want to thank the members of both our Research Advisory Group and our Research Ethics Committee for their advice and support of the work. Your expertise guided and strengthened the study. And I want to pay special tribute to Jackie Brown, who was a member of the Research Ethics Committee and who sadly passed away in June 2025. I know Jackie is much missed, and may she rest in peace. We would also like to acknowledge the input of the Health Research Consent Declaration Committee, who granted a consent declaration for the research, and the President of the High Court, who granted an order permitting all people made a ward of court to participate in the research. And we would also like to extend a particular word of thanks to the Office of Wards of Court for their assistance in the work. This included their support in disseminating information about the research, providing anonymised data, and also details of discharge hearings. And all of this was essential to our work. The assistance provided by the Court Service of Ireland is also acknowledged with thanks. But most importantly of all, the NDA acknowledges with gratitude the contribution of those people who were made wards of court for sharing their experiences with us. And without them, this research would not have been possible at all. We also thank those members of the committees and other key informants who generously shared their time and participated in the research. So now, without further ado, I'm going to hand over to Nora and to Kieran, who will begin the presentation on the findings of the research, and I'll return to close out the session at 12 o'clock.
Thanks, Aideen, for that. Okay, so the journey from wardship to supported decision-making, an examination of the process and experiences of people leaving wardship. So the Assisted Decision-Making Capacity Act commenced on the 26th of April 2023. It marked the phasing out of the adult wardship system in Ireland and aligned Ireland's legal framework with Article 12 of the UNCRPD. Prior to the Act, legal capacity was viewed in black and white terms as either present or absent. But the Act provides for a graduated system of decision-making supports. The wardship system also operated under a best interest model, with the courts making decisions based on what were deemed the best interests of a person. The Act provides for gives precedence to the will and preferences of persons who require decision-making supports. It also provides that all adults shall be discharged from wardship within 3 years. As some of you may be aware, there have been recent developments in this, and we will come to that at the end. So the aim of this work is to examine the process and experiences of the cessation of the system of wardship in Ireland and the commencement of the supported decision-making system. This was a mixed method study which incorporated 4 different strands of research conducted over a 2-year period. Strand 1 was the secondary data analysis of anonymised data provided by the Office of Wards of Court. Strand 2 was qualitative analysis from interviews with persons who have been or were made wards of court and committees. Strand 3 was qualitative analysis from interviews with key informants, and Strand 4 was observation of discharge hearings. So firstly, looking at Strand 1, which was the secondary analysis of data provided by the Office of Wards of Court. So table 1 here shows movements in and out of wardship from the commencement of the Act at the end of April 2023 to the end of November 2025. So at the commencement of the Act, there were 2,173 adults in wardship. The Act provides that applications for admission to wardship submitted prior to the commencement of the legislation remain in force. So following the commencement of the Act, 166 adults were admitted to wardship. The majorities of these admissions occurred in the first 16 months of the Act. From the commencement of the Act to the end of November 2025, 250 adults were discharged from wardship. This has meant that the total number of adults in wardship at the end of November 2025 was 1,602. This equates to 74% of the adults in wardship at the commencement of the Act that were yet to be discharged. Of those discharged from wardship at the end of November 2025, the vast majority of these were appointed a decision-making representative. This is the highest tier of support provided for under the Act. 13% of those discharged from wardship, the court determined no support arrangements would be required. Only 9% of those discharged were discharged with the support of a co-decision maker. Now looking at strand 2, which is the qualitative analysis from interviews with persons who have been or were made wards of court and committees. 27 participants took part, 16 of whom have been or were made wards of court, and there were 11 committees. The discharge status of these participants is presented in the slide. In 33% of cases, the individuals had initiated the discharge proceedings. 26% of participants had gotten as far as applying for legal aid. A further 22% of participants had not yet started the discharge process, and 19% of participants had completed the transition out of wardship. In terms of the findings, 4 themes emerged from the analysis, and these are presented on the slide. These concerned admission, wardship, discharge, and post-discharge. In the interest of time, I'll go straight to theme 2, which is wardship. In the interviews, there was a strong sense of wardship as being disempowering. Phrases such as having no control, no freedom, and the courts deciding everything for me were repeated across a number of interviews. This resulted in what appeared to be a diminished sense of personhood, as participants who were in or recently discharged from wardship described the need to ask for permission relating to many aspects of their lives as demeaning, as this individual said, "I should not have to ask permission. I am," and she names her age. "I can do what I want to do. I'm not a child. I'm not 16, or I'm not 6. I'm an adult." Money management featured prominently when participants spoke about their experiences of wardship. There was a clear frustration in not having access or control over their money. Both those in or recently discharged from wardship as well as committees felt it was demeaning for someone to have to ask permission to spend what was essentially their own funds. As this individual said, "You have to go like a child. Give me some money to buy this, you know." That was a little bit embarrassing. There was also an element of reassurance provided by the Office of Wards of Court in managing funds. This was reflected both in the interviews with those in or recently discharged from wardship as well as committees, as this individual said, to have that support, that security, financial security, that they were investing the money for us and we didn't have to worry about that. People do not understand how safe we feel with that and how vital that was. This support and reassurance that committee spoke of related not just to the management of funds. Committee spoke about how the court, through the assistance of the Office of Wards of Court, had advocated for the person in wardship with a number of state agencies, for example with the HSE, in securing respite, home help, assistive technologies, wheelchairs, adapted cars, beds, and a range of equipments. For these committees, the intervention provided by the court in that application provided more weight than would have been possible had they done that application alone. So looking at the next theme, theme 3, discharge. The majority of participants reported on what appeared to be an information vacuum around the end of wardship. Participants often described how they did not know or were not sure either about the information provided or the transition process as a whole. This created a sense of ambiguity in navigating the process, as this individual said. "We really have heard nothing, and we do not know what's going on and how it works. We just don't know where to go, what to do, what to expect, and we're not being told." While participants repeatedly reported feeling lost, there also appeared to be a disconnect in the provision of information and engagement with that information. There was a sense across the interviews in which it was common for participants to have overlooked, or chosen not to engage with the information that had been provided by the Office of Wards of Court. Participants' concerns and apprehensions regarding discharge and the transition from wardship emerged strongly in the analysis. There was an apprehension to embark on an untested process and concerns about the withdrawal of the support of the Office of Wards of Court following the transition from wardship. There was also concerns around the management of money following discharge, and this featured prominently in interviews with committees. Participants described how they were apprehensive around their financial skills, as this individual said, "What am I going to do with all this money? Who's going to help me? That's a bit frightening. It's an awful lot of money. It's an awful lot of responsibility." 5 participants had completed the discharge process, and when these participants discharged from wardship reflected on their experiences, there was a sense in which they were peripheral to the transition. As this individual said, "I just went along with everything. What else could you do?" One committee spoke about the challenges in finding a solicitor that would take on the case. But for those who had been discharged and attended the court hearing, this was found to have been a positive experience. Okay, looking at post-discharge then, theme 4. There was a nuanced psychological transition that emerged from the interviews with those in or recently discharged from wardship. It became apparent that as participants considered the transition, they were navigating a complex landscape. Having been made a ward of court for some time, the discharge brought with it a sense of empowerment, along with fear and anxiety from the responsibility that they now felt. As this individual said, "It's brilliant. It's a relief. It's hard to get used to because you were so tied up and so controlled for such a long time by people telling you to do what you were told." For those still in wardship, the anxiety around their potential discharge was so overwhelming, there was an element of coping by withdrawing or trying to avoid thinking of it. As this individual said, "I hate everything about it. I don't want to take it over fully by myself, and I don't know if I ever will, so I want somebody to help me." A lack of information or understanding of the role of the Decision Support Service, the DSS, emerged strongly in the analysis. As committees had traditionally liaised with the Office of Wards of Court, they appeared to regard the DSS as the replacement of the Office of Wards of Court, and thus they believed that the DSS would provide support to persons who are wards of court and their families in the exact same manner that the Office of Wards of Court had. When it became apparent that this was not the role of the DSS as outlined in the legislation, there was confusion followed by frustration and apprehension to engage with the organisation. As this individual said, "I assumed that they were there to help with decision making, which I thought was brilliant, that someone could make this decision for us, but I didn't really realise what it was." Okay, so turning now to strand 3, which was the qualitative analysis from interviews with key informants. So 22 interviews were conducted with 36 key informants. The largest group of professionals worked in the legal system. This included members of the judiciary, senior counsel with expertise in mental health and capacity law, senior officials in the court service, including those providing support and oversight to wards of court, decision-making representatives and solicitors. The next group of informants, including representatives from various public bodies involved in the areas of health, capacity, advocacy, and legal supports. The research team also interviewed representatives from other areas. These had experience and expert knowledge in the system of wardship and the transition to supported decision-making. 4 themes emerged from this analysis. These centered on reflections on the wardship system, reflections on the discharge process, decision-making support arrangements, and post-discharge. In the interest of time, I'll go straight to theme 2, which was reflections on the discharge process. The discharge process was regarded as complex and multifaceted. As this individual said, The process under the Act is pretty unwieldy. It's very resource heavy. However, the frustration with the complexity in the discharge process emerged strongly for interviews conducted in 2023 and 2024, but this was less apparent for the interviews conducted in 2025, as this individual said. There was obviously a teething process in terms of figuring out how it works, but those issues seem to be ironing out. For those involved in the functional assessment of capacity, there was a feeling that if it were possible to have more information on the individual prior to conducting the assessment, this could improve the quality of the assessment. There was also ambiguity around legal aid at the beginning of data collection. Participants felt were afraid if they would be subject to clawback of legal costs. But over the course of data collection, this was clarified that applicants would not be subject to the clawback of legal costs. Okay, turning to the next theme then, which was around the decision-making support arrangements. So firstly, looking at co-decision-making arrangements. The absence of a panel of co-decision makers was raised by a number of key informants. This was reported to be challenging for those who may need a co-decision maker but didn't have anyone in their lives that might be able to fulfill that role. When this happens, a decision-making representative can be appointed. Key informants raised concerns that replacing a co-decision maker with a decision-making representative could lead to substituted rather than co-decision making for the individual. Also, where a person is deemed to lack capacity unless the assistance of a suitable co-decision maker is available to them, discharge from wardship is contingent on the registration of the co-decision making agreement with the DSS. A number of aspects related to this were raised during the interviews. Firstly was the importance of the provision of legal aid to assist with the registration of these agreements. Secondly, there appeared to be an ambiguity in the time involved to register the co-decision-making agreement. This differed across interviews and source material consulted as part of the review. Next, looking at the decision-making representative arrangements. A number of key informants discussed how Part 6 orders in discharge proceedings can be broad when raging. This could lead to frustration with certain organisations such as banks, when individuals need to go back to the court for clarity on what their authority covers. There also appeared to be inconsistency in the degree of information a DMR would receive prior to taking on the role. Professional DMRs indicated that often they're not aware of the complexity of a case or the needs of an individual, and this could impact on the quality of and continuity in support individuals receive as they transition from wardship, as this individual said. I just feel it's very abrupt. It would be more appropriate if the proposed DMR had the opportunity to go out and meet with the ward to know whether they can take on the role or not. Okay, looking at post-discharge then. The concerns around money management of funds following discharge that emerged strongly in the analysis and interviews with committees were also apparent in the interviews with key informants, as this individual said. I wouldn't be at all confident that people who are being discharged with funds can be adequately protected in terms of funds. I wouldn't be confident at all about that. That would have been a major concern. Key informants recognised that the fear and apprehension that families felt around the management of funds resulted in a reluctance to initiate the discharge proceedings. It was also suggested that there is a misunderstanding related to the management of funds, as one informant clarified. Where there is some anxiety around the management and investment of funds, you seek independent financial advice. You get that expert and specialist skill set involved. That's been a real learning curve. Okay, I'll now hand over to Kieran, who is going to take us through the observation of discharge hearings.
Great, thanks so much, Nora. I'm going to take you through the last strand of the research that we did, which related to observations of court discharge proceedings. Sorry, just there now. So we observed 66 discharge hearings in total during the course of data collection up until the end of the 31st of August 2025. Those cases were chosen at random, and of those 66 cases that we observed, it resulted in 59 people being discharged. That accounted for 37% of all discharges up until the end of August 2025. So we're quite confident that we got a good spread of cases that we observed. 7 of the cases resulted in adjournment, so the individual wasn't discharged at the hearing. Of those decisions, or of those hearings that we observed, most of the applications were initiated by the General Solicitor for Minors and Wards of Court, who serves as committee for about a third of people in wardship. But just to say that of those hearings that we observed last year, we did see more cases coming on stream from private committees. In terms of the outcome of the cases that we observed, they resulted in 49 decision-making representatives being appointed, 7 people discharged without decision-making support, and 3 individuals who were discharged with the support of a co-decision maker. But just to say that the discharge does not become effective in terms of a co-decision maker until the co-decision making agreement is registered with the Decision Support Service. Also, in relation to those decision-making representative numbers, so there was 49 decision-making representatives appointed, and of those, there was 35 panel DMRs, so professionals from the panel maintained by the Decision Support Service. So about 70% of DMRs were from the panel. In terms then of attendance of persons who were made ward of court at the proceedings, so the legislation provides that individuals should be present and that the hearing should take place in the presence of the person who is discharging from wardship, although there are a number of exceptions to this. So one of them being, for instance, that where the proceedings or attendance at the proceedings may adversely affect the health of the person, then the proceedings can go ahead. On all of the cases that we observed, there were measures outlined as to what was taken to support the individual to participate or attend at the proceedings, and those being whether the option of remote attendance was offered to the person, or whether support in terms of a care worker or a family member may have enabled or facilitated attendance at the proceedings. Of the 66 cases that we observed, 30 people attended the cases remotely, 26 did not attend, and 10 people attended in person. So about 40% of people were not present at the discharge hearing. In terms then of participation in the discharge proceedings, from our observations, there was limited opportunities to participate in the discharge hearing. The hearing itself predominantly consisted of a dialogue between the presenting solicitor or barrister and the judge. Notwithstanding this, however, individuals who did attend the proceedings or the hearings, they were welcomed by the judge and almost always offered the opportunity to speak to the court and share their views in relation to their will and preferences, although this was not compulsory, and it was stressed that they didn't have to engage or speak to the court if they didn't wish to. We did observe a limited number of occasions where language and communication within the courtroom setting was of a more complex nature and may not have been accessible to individuals. So, for instance, references to evidence being uncontroverted, or on one occasion, a judge asked a decision-making supporter about seeking relief. So some of those instances we felt may not have been very accessible to individuals who were laypersons and not familiar with legal terminology and jargon. However, we did see that there was significant efforts taken to make sure that the hearings were accessible. So we've seen members of the judiciary speaking slowly, explaining legal terminology and processes like a notice of motion, an affidavit, talking to them about their interests and their passions. And for instance, we observed one particular case where a football fan was explained what it meant by a DMR in reference to a football team. So this particular individual had a network of support around him, and the judge likened it to a football team, saying that the DMR was just another player on the team who would assist him in his life. One of the things that's new with regards to the legislation that was introduced or commenced in 2023 is that legislation requires that the will and preferences of the person are very much paramount when it comes to making their decisions. We seen and observed in the cases that we were present at that great weight was afforded to the will and preferences of the person, even in circumstances where they were deemed to lack decision-making capacity. So, for instance, whenever a person was being appointed or sought their views in relation to a decision-making supporter, we've seen great weight attached to the preference of the individual in that regard. And so, for instance, in one case, we've seen a social worker express reservations about the appointment of a particular family member as a decision-making supporter. And notwithstanding these reservations, the individual or the family member was appointed as a decision-making supporter because that was deemed to be the will and preferences of the person. We also observed instances where findings in relation to some of the functional capacity assessments were rejected by the judges because they were deemed to be determinations or assessments based on the best interests of the individual as opposed to their will and preferences. So, for instance, in one of the functional capacity assessments, it was stated that the individual may benefit from some support in terms of financial skills. And what the judge said was actually their financial skills haven't been tested yet. And that assessment was based on what their best interests would be. And so that was not accepted. We also observed a small number of cases in relation to funds of a significant nature. And in those particular cases, there was a proposal provided to the court with regards to the future management of those assets. Those particular financial plans were very much appreciated by the judges. But just to say that judges were reluctant and did not endorse or approve any of the financial plans which were put forward or submitted to the court. So, for instance, on one occasion, there was 2 proposed decision-making representatives. They said that they had sought financial advice and there was 2 financial plans that they were considering, one which was deemed to be medium risk, one which was deemed to be medium high risk. And the judge said that he wouldn't second guess whichever option that they would proceed with, but he was reassured by the fact that they had received and obtained a financial plan and that they had also sought out financial advice. I'm now just going to highlight some maybe broad themes that came out through the research. I want to flag that these are not exhaustive and I would encourage people to read the report. But in terms of some of the broad issues, the first related to barriers to engagement with the process. So one of the things, as Nora has pointed out, that really came across and emerged as a strong barrier to engagement with the discharge process related to the management of funds. And really what we heard from a lot of committees is that they felt overwhelmed in relation to their current role, many of whom were providing supports to individuals in wardship, and felt that they would find it difficult to take on a new role with regards to undertaking a decision-making capacity role. There was also a resistance to change. So there was a reluctance to embark on what was considered to be an untested system, whenever many people felt that they were quite happy with the current arrangements and the support provided by the Office of Wards of Court. Just to say that those barriers were barriers particularly for committees, but for some people in wardship as well. But notwithstanding that the numbers of people who were discharged up until the end of November of 2025 was quite low, it must be acknowledged that significant efforts were undertaken to promote engagement with the discharge process, and a number of developments occurred over the course of the period as well. So one of the things that was really spearheaded was a substantial information provision campaign, which was led by the Office of Wards of Court, and that was supported as well by a number of other public bodies, including the Decision Support Service and the Legal Aid Board. But notwithstanding that information provision, there was individuals who, as Nora mentioned, felt a bit lost in the process, felt that they didn't have all of the information available. And one of the really positive things which occurred last year in response to that was the provision of in-person information days. So the Office of Wards of Court organised a series of information days in person for individuals who were committees or discharging from wardship themselves. These took place around the country and were really gratefully received and well received by individuals, some of whom had travelled long distances to attend them. As well, one of the things which occurred was developments around legal aid. Nora has also referenced those, so I won't go into them in too much detail. High Court Practice Direction as 133 was introduced in summer of last year, and really that provided for two new developments. First of all, the papers now only have to be served on an individual who is discharging from wardship on one occasion. So now there's only one occasion, or a minimum of one occasion, on which an individual may be visited by a solicitor to elicit their will and preferences. And that's reduced the workload around discharge applications and proceedings for solicitors. Another development with regards to that particular High Court Practice Direction is that it widens the pool of people or assessors who can undertake the functional capacity assessment. So up until summer of last year, only the medical court visitors could undertake the functional capacities of assessment, but now registered medical practitioners, as defined under the legislation, can also undertake those capacity assessments. Just to say that there is a wider pool of healthcare professionals who can undertake functional capacity assessments under other parts of the legislation. There's currently two streams for discharge, which are also underway. One of which is individuals who have voluntarily engaged with the process. And now anybody who has not engaged with the process up until the end of October has been mandatorily listed. So even if you haven't engaged with the process now, everybody is being brought on stream and is being mandatorily listed with regards to their proceedings. Sorry now, just having trouble moving through. Nora, can you move that presentation on? Perfect, thanks so much. So in relation to then just a few other quick points, Nora mentioned as well that the lack of panel for professional co-decision makers is something which arose during the course of the research. So in circumstances where an individual may not have someone in their lives who can act as a co-decision maker, a decision-making representative is appointed and is required to act jointly with that particular person. And some of the stakeholders felt that this may be leading to more decision-making representatives being appointed than may be necessary. One of the things as well that's come across with regards to the data and statistics that we received is that many of those who are being discharged from wardship are being appointed a decision-making representative, which, as Nora mentioned, is the highest tier of support. In those circumstances, a decision-making representative is making decisions based on or on behalf of the person who is leaving wardship, although it is different to wardship in that those decisions should reflect, insofar as practicable, their will and preferences rather than their best interests. Just two other quick things just to mention as well. One of the things which came across in the research is that there was a preference and a disappointment, I suppose, that protection of liberty safeguards legislation wasn't introduced alongside the ending of the wardship system. So essentially, at present, there's no statutory framework in place to ensure that people who may lack decision-making capacity are not unlawfully detained. And so some stakeholders felt that individuals remained in wardship for a longer period of time because of this, and also that this may have served as somewhat of an incentive for people to continue to be admitted to wardship post-commencement of the legislation because they could be detained under the wardship jurisdiction. Another thing which came across in some of our interviews with service providers is that they weren't sure about their role in the particular process, and also sometimes receiving conflicting advice about whether or not they could initiate the discharge proceedings. Nora, do you mind moving to the next slide there as well? Thank you. In terms of recommendations, I'll just run very quickly through those. The first relates to ensuring that the Court Service, Decision Support Service, the Legal Aid Board, and the National Advocacy Service for People with Disabilities are adequately resourced, particularly given the fact that a very high number of discharge proceedings are going to come on stream over the coming months. Another recommendation is about clarifying options where discharge hearings are not completed by the deadline, and I'm going to come back to that in relation to our last slide. We also highlight a number of areas where enhanced information provision may be beneficial. So many of those who are now engaging with the process have not engaged with the process to date and have been mandatorily listed. And so we may need to consider what forms of information provision may be appropriate for them, such as, for instance, holding an in-person information day now because more of them are now engaging with the process. A point of confusion as well, which arose for some committees and people in wardship, was the functions of the DSS as compared to the Office of Wards of Court. So some feeling, as Nora had mentioned, that the DSS was going to do the same work as the Office of Wards of Court. So distinctions and information provision in relation to the differences may be useful. Some people as well weren't clear about the pathway through the discharge process as well. And that's something that we felt that more information could be provided on. And then reflecting some of the concerns that committees had with regards to financial concerns, we felt that there could be more information provided about how best to address those particular concerns. In terms of the information and awareness provision, one of the things as well that we think might be useful is that a number of people have now been discharged from wardship. And is there a role for them to play in terms of raising awareness, allaying concerns, if they would be willing to do so? Nora, perfect, thank you. In terms then of some other recommendations, one of the issues which Nora alluded to was about considering further information provision prior to the assessment. So one of the things that came across was that assessors would like more information around communication preferences, activities of daily living, the types of decisions that people make on a daily basis. Decision-making support arrangements then, one of the things which came across was considering the establishment of a panel of co-decision makers, just to say that if that measure was to be adopted, it would require an amendment to the legislation. And then post-discharge as well. One of the things that came across, as Nora mentioned in her presentation, was that individuals who are coming out of wardship, even those who have been deemed not to need decision-making supports, were apprehensive about their experience, about their decision-making skills. So even though they may have been considered to have decision-making capacity, they may not have had experience, particularly in recent time, of making decisions. So what supports would be needed in terms of assisting them to build up the skills and capacity to make decisions in their lives? And so, for instance, would advocacy supports be something beneficial in that regard? And then just turning to our last slide, just very quickly, as some of you may be aware, there's been developments which have recently been announced by the Department of Children, Disability and Equality. Essentially, what will happen is that the Assisted Decision-Making Capacity Act will be amended, or Part 6 of that Act will be amended. And essentially, the current timeframe will remain in place in terms of the 26th of April 2026. However, there will be discretion to extend that deadline. That will be for a maximum of 18 months. So that will mean that wardship will end by the 25th of October 2027. Just to say, it's not a blanket exemption or extension. Decisions will be made in terms of the extension will be made on a case-by-case basis. So all proceedings and hearings will be heard before the 26th of April in terms of deciding whether or not an extension will be required. A general scheme and heads of bill have been prepared by the department, and I understand that these will be progressed over the coming months and in advance of the deadline. Just to say that in terms of these developments, what we would say is that it's important to raise awareness about these developments, particularly for people who may be apprehensive that their particular discharge hearing may not be heard before the 26th of April. And that concludes the presentation there. Thank you.
Thank you very much to Kieran and Nora for taking us through that flavour of the findings and recommendations from the report. As we've said already, it is on our website, nda.ie, and it is quite a meaty document, but it comes with a very good executive summary and also the easy read version. So we do encourage people to take a look. So now we have just slightly under 15 minutes for any questions. And I see a few in the Q&A box, but there is still time if you want to input a question in there just while I take us through the first few ones that we've received. So the first question is from Maria Pierce, who is calling out that statistic in relation to the percentage of wards of court who were discharged to a decision-making representative order. So she notes that you've said 78% were discharged on that basis, and wondering, was that a surprise? And did the wards themselves have any particular perspectives on that when you met them? And I suppose I'll just cover off a related one as part of that and then hand to you, perhaps, Kieran. Can you clarify what is meant by panel decision-making representatives, and is there an alternative to that?
Yeah, thanks so much. I'm happy to jump in first, and Nora, please jump in after. So in relation to decision-making representatives, taking the questions in reverse order, so where an individual is deemed to need a decision-making representative, there can be two particular people that would undertake that role. It may be someone who is known and trusted by that individual, who would be a non-panel DMR. So typically that's a family member. And in some cases, that's the individual who previously acted as their committee. So that's one particular scenario that may occur. And then the second one is a panel, which is maintained by the decision support service. So where an individual doesn't have someone in their life who can act as a decision-making representative, that may be a professional who has registered with the decision support service and will be offered as an individual who can undertake that role and serve in that role in that person's life. In terms of the 78% statistic, I suppose there's 2 points that I want to make maybe in relation to that. In some ways, I suppose we can see that there is a high reliance in relation to the DMR tier, which is the highest tier of support which is available. Individuals who are in wardship have been deemed at one stage in their lives to be incapable of managing their own affairs. So maybe in that sense, it's maybe less surprising that there is a higher number of DMRs, but I do think it's something that requires close monitoring. As well, one of the things that I mentioned is that in some of the discharge proceedings that we observed, in 5 of those particular cases, an individual was deemed to need a co-decision maker, but didn't have someone in their life to do that particular role. And so a decision-making representative was appointed to that individual to act jointly with them. So there is possibly some cases where an individual may actually benefit from a co-decision maker, but is being appointed a decision-making representative. And in terms of views around that, I suppose we only were able to interview 5 people who were discharged from wardship. Of the 5 people that we did interview, 4 of them had been discharged with no decision-making supports, and only 1 had been discharged with a co-decision maker. So we actually didn't get an opportunity to interview any individuals who are utilizing the decision-making representative tier. And so I think that's important to point out. There is a review which is provided for within the legislation. So there has to be a review of the legislation within 5 years. And one of the recommendations that we have in the report is that there is consideration given to how life has changed for individuals who were in wardship and who are now availing of the decision-making representative option, because I think it would be really valuable to see how and in what way life has changed for them post-wardship.
Great, thank you, Kieran. I might pass the next question I have in front of me to Nora. It's from Stefan Story of the Department of Health, and he's asking a maths question, so that's why I'm asking you, Nora. He's talking about the first table that you presented, where you had the percentage of discharge arrangements. And he's saying, how do you count the percentage when a person has, for example, a decision-making representative for property and affairs, but a co-decision maker for welfare decisions?
Yeah, that's a good question. Unfortunately, at the moment, the data that was provided to us, it would not be possible to make that distinction. We would need to allow for a second variable to supplement the analysis with that. So it is a good point because that is a possibility. We just had one variable, which was what was the decision making or what was the discharge order, whether it was the DM or the decision making representative, co-decision maker, or discharge, where no decision making support arrangements were required.
Okay, thank you very much for that, Nora. Just some more questions coming in here. Somebody is asking about whether the information provided on the discharge process aligned with alternative augmented communication methods. So, for example, plain English or easy to read or the use of visuals. So I don't know, either Nora or Kieran, do you have any light to shed on that?
Some of the information was provided in easy to read versions. I can't say that we've had sight of all of the information which is out there. And just to say, there is a lot of information which is out there. A number of public bodies, as I mentioned, are providing information. The Decision Support Service, Legal Aid Board, the Office of Wards of Court. And as well, there are other bodies out there, especially the National Advocacy Service for People with Disabilities, who's been assisting a number of people with regards to their applications. There has been definitely some information which is provided in alternative formats, but the extent to which we didn't, I suppose, look at all of the information in the round that was out there. We were also just, I suppose it was just a point that came through with regards to the information or the points that individuals raised with us in the interviews.
Great, thank you, Kieran. Coming back to that question of DMRs, Melissa Leonard, who is part of the National Advocacy Service, is just checking to clarify that if a person does not have a panel member to support with a co-decision making arrangement, does that mean that if a DMR panel member supports, that the person is part of a DMR rather than a co-decision making arrangement? Is that the case?
Yeah, so happy to clarify on this. So essentially, what happens is that where an individual doesn't have someone in their life who can act as a co-decision maker, they are then appointed a decision-making representative. And that decision-making, so that's the outcome, a decision-making representative. And as per the legislation, that individual, the DMR, is required to act jointly with the person. So effectively, operates like a co-decision maker in terms of making decisions jointly with them, but the outcome is that they're appointed a decision-making representative. There is no provision within the legislation as currently drafted to allow for professional co-decision makers. And so one of the recommendations that we have is that consideration is given to that, especially because it may actually assist individuals who wish to serve in that role to hone their skills in that regard, because some decision-making representatives will be making decisions on behalf of individuals, and some may be making decisions jointly with an individual. But that would require an amendment to the existing legislation. It's not provided for and wouldn't be allowed under the current statutory framework.
Thank you for that clarification, Kieran. Joanne Finnegan is asking, do we know, is there a list of health professionals available who are eligible to complete functional capacity assessments, and can a registered health professional apply for same? I'm not sure if we have that information. I'm
not sure. So in terms of healthcare professionals, just to say, one of the changes that was introduced last year through High Court Practice Direction 133 is that it's only registered medical professionals and court medical visitors who can undertake the functional capacity assessments for the purposes of a Part 6 discharge application. So there are a number of other parts to the assisted decision-making capacity legislation. It's a huge act. Our research was only focused around Part 6, which relates to individuals who are in wardship and exiting wardship. But there are a whole suite of supports and provisions under the Act which we didn't look at in terms of the research. So we don't have that information. But just wanted to flag that in terms of the particular research that we were undertaking.
Thank you very much, Kieran. And now might be a good time to highlight a comment that we've had from Anya Flynn, who is the head of the Decision Support Service, who congratulates the team on the launch of the report. But she does point out that more information on the role of the Decision Support Service following discharge is available on their website, which is decisionsupportservice.ie. And that also has some more information about the various supports and resources that are available under their remit. So what we can do after this is we can share the contact details for the Decision Support Service to our attendees, but the website is a good place. So as I say, decisionsupportservice.ie. And I think at this stage, I just have time for one more question. And it does relate to the final slide, the breaking news you had, Kieran. So somebody is asking, are they correct in understanding that all individuals awaiting discharge will be in court by the 26th of April 2026, regardless of whether their case will be extended or not? So I'm Kieran, that might be for you as well.
Yeah, so essentially I suppose extension of the deadline isn't a blanket extension. So essentially the court will, before the 26th of April deadline, have to decide whether or not a case is going to be extended. And because of that, there will have to be a decision made in advance of that on each case, whether or not an extension will be provided. The statutory deadline remains in place, but as I said, there will be an extension provided where it's necessary and in the interest of justice of doing so. But there will be an outer time limit in terms of that particular extension. So October of 2027 will be the ultimate extension. And I suppose the expectation and hope is by maintaining the deadline as it currently is that there will be, and as expected, there will be a lot of cases coming on stream over the next while that will result in individuals being discharged in greater numbers over the coming months. And we've seen in the last couple of months of 2025 and in early 2026, a very big increase in the numbers of people who are coming out of wardship. And we expect that will continue as well. It will require additional resources, more judges sitting, additional court resources. So there will be a lot of capacity constraints, or I suppose required in terms of meeting those. But one of the things as well that we think is important to do is to really highlight this to committees and wards of court so that they're aware and that they have the certainty as well in case they are apprehensive around the upcoming deadline.
Brilliant. Thank you, Kieran. And I'm noticing that Caoimhe Gleeson of the HSE is also flagging that they have some more information available on their website or through an email, which is adm@hse.ie. So we'll add that to the information we send out. But I'm sorry that we don't have time to get to all of the questions that we've had. But as I said at the start, the team will get back to people following the close of this session. And if you have thought of something else in the meantime, you can feel free to email us at wardsresearch@nda.ie. So now it's time for me to bring proceedings to a close. I want to thank you all for your attendance and your engagement through the questions. You clearly highlighting the level of interest in this very important topic. So thank you all. And I just want to round up with a few thank yous, both for today's event, but for the research itself. So first of all, thank you very much to Leila and Willie for the ISL interpretation throughout today's event, and also our webinar support team. So that's Cormac Staunton of Staunton Media. Thank you, Cormac. I particularly want to thank Nora and Kieran for presenting today, but also for all their work on bringing the research to its conclusion and getting the report to the stage when we can now publish it. And thanks also go to people who are not on screen. So Rosalind Tamming, who is our Head of Policy Research and Public Affairs. So, leading the entire team who were involved in this. And there were also a number of colleagues behind the scenes, including Bevan Murphy and Maeve Ryan, both supporting the research and also supporting the preparations for today's event. And I also just want to acknowledge a former staff member, Dr. Caroline O'Nolan, who started this research 2 years ago and carried through some of the earlier work and has since left. So as I say, the report's now on our website along with its easy read version. What we've heard today just gives us a snapshot. As you can see, there's a lot of detail and a lot of perspectives and areas to consider, and the report covers them all. So do feel free to reach out to us if you have questions once you've engaged with the report. We'd be very happy to hear from you. But I just want to say thank you again for joining us today, and hopefully everybody enjoys the rest of their Wednesday. Thank you all.